May the prosecution approach the stands.
Today, a young man by the name of Matthew Fraser and his father are in court today because Matthew got suspended at school for saying something rather interesting. I would like to present Exhibit A. This is a speech that Matthew Fraser delivered to his school's entire student body about his friend who is running for student council vice president. I know a man
who is firm. He's firm in his pants, he's firm in his shirt, he's firm in his character, but most of all, his belief in you, the students of Bethel, is firm. Jeff Coleman is a man who takes his point and pounds it in. If necessary, he'll take an issue and nail it to the wall. He doesn't attack things in spurts. He drives hard and pushing until finally he succeeds. Jeff is a man who will go to the very end, even the climax, for each and every one of you. So please, vote Jeff Coleman, as he'll never come between you and us and the best our school can be. Thank you. Thank you. What the heck? I mean, come on. That was pretty good.
This sort of language was in clear violation of the Bethel County School District's Code of Conduct, which reads, "Conduct which materially and substantially interferes with the educational process is prohibited, including the use of obscene, profane language or gestures." Mr. Fraser's speech was offensive, distasteful, and disruptive, and as a result, he was suspended from school for 3 days and his name was removed from the ballot for graduation commencement speakers.
Unbelievable. I don't understand why my son had to be suspended. He was well within his First Amendment rights. I mean, this is America. He should be free to say whatever he wants. Who does this principal think he is? So I went to the school's principal, right? And I was like, my son is well within his rights. And the principal was like, not at my school, he isn't. And I was like, what the heck? So then we went to the court, the United States Court of Appeals for the Ninth Circuit specifically. Don't know why I know that. And since my son is a minor, I have to speak for him. So our lawyer was like, First Amendment. And the court was like, maybe not. But Matthew's punishment does violate the due process clause of the 14th Amendment. So let the kid speak at his graduation. So basically, since my kid's speech was apparently similar to the one stated in the Tinker case, since it caused a disturbance, well, you know what else is a disturbance? When your son has to stay back home. Anyways, because of this decision, it was declared that the officials had no right to authorize the speech found at a school-sponsored event, aka we won. But of course, the school didn't take it like that, and they requested that we take this to the Supreme Court.
Karen, yes, I know. Listen, we don't agree with the lower courts. They already made us award that kid with $278 in damages and more than $12,500 in litigations. Do you understand that? Do you understand the problem that we're in right now? You can't even forget the attorney fees. And now, we're not backing down on this fight. We don't agree with what the lower courts have decided, and we will win this battle. Our district has agreed and discussed that the actions which Mr. Matthew Fraser undertook during this public announcement was completely inappropriate. That is why we nominated this case in order to be sought by the Supreme Court. And fortunately enough, we were granted the writ of cert that we needed in order to pass with this hearing. Today on March 3rd, 1986, we will be hearing the case of Bethel School District versus Matthew Fraser. Matthew Fraser is a student who delivered a speech in front of an audience that consisted of approximately 600 students, in which many were 14-year-olds. Found within his speech was a constant usage of elaborate, graphic, and explicit sexual metaphors to refer to another student at Bethel. Upon completion of the speech, it caused disruption as many students responded out towards it. Prior to delivering his speech, he asked for feedback from multiple teachers, in which only 2 deeming it was inappropriate. The following day, Matthew was called to the assistant principal's office, in which notified him that his speech was disruptive and inappropriate. As a consequence for his actions, he was given a 3-day suspension, and his name was removed from the list of possible speakers at graduation. His father then sued the Bethel Country School District for violating his son's First Amendment rights. The District Court and Court of Appeals ruled on the side of Fraser, citing the case of Tinker versus Des Moines Independent Community School District, in which this court stated that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. This led to the Frasers getting compensations. However, Bethel School District requested for a writ of cert, in which requested the Supreme Court to take the case, in which it ultimately was granted.
Through a 7-2 decision, the Supreme Court has decided in favor of the Bethel School District. We hold that the petitioner, the school district, acted entirely within its permissible authority in imposing sanctions upon Fraser in response to his offensively lewd and indecent speech. Unlike the sanctions imposed on the students wearing armbands in Tinker, the penalties imposed in this case were unrelated to any political viewpoint. The First Amendment does not prevent the school officials from determining that to permit a vulgar and lewd speech, such as the respondents, would undermine the school's basic educational mission.
As a dissenting opinion, I believe we may not unquestionably accept a teacher's or administrator's assertion that certain pure speech interfered with education. Here, the school district, despite a clear opportunity to do so, failed to bring in evidence sufficient to convince either of the two lower courts that education at Bethel School was disrupted by respondent speech. I therefore see no reason to disturb the Court of Appeals judgment.
Thank you.
You still lost.
After 3 long years of fighting in court, we finally won. This victory has really set a precedent for a school speech for years to come, and I couldn't be happier that we are finally over it. Is that it? Are we done here?
Yeah, we're done.
Okay. Whoa! Eat it, Fraser! Eat it!
It's been 30 years since my Supreme Court trial, and yeah, that loss still stings. But it all worked out in the end. Nowadays, I work as a debate coach at Stanford. Ironically enough, that Supreme Court decision made it clear that students do not have the same freedom of speech at school that people do elsewhere in America. Schools are free to censor and prohibit language if they deem it vulgar, offensive, or disruptive. This came up as recently as 2007 with the case of Moore versus Frederick. There's a student, Joseph Frederick, who was suspended from school after holding up a sign at a school rally that read "Bong Hits for Jesus." Man after my own heart. That's beautiful. The Supreme Court maintained its stance that schools are able to restrict language if they consider it vulgar. So, in the end, I kind of ruined it for everyone. Oh well, I still believe that students should have complete freedom of speech in school, and I'll stand firm in that belief.